Got a post here about a dispute between a landlord and a tenant about what the terms of the lease or rental agreement are, and now there's an evidentiary dispute about what the terms are. How does the court figure out who's telling the truth and doing what they're supposed to do? Hi, my name is Rob Wells. I'm the Landlord Warrior on TikTok and YouTube. Please feel free to like, share, and subscribe to our videos. Now, you know what? This commenter brought up a situation I ran into court several weeks ago, actually, where there was an actual dispute about the lease. Okay, there was a dispute about what the actual terms of the tenancy were regarding the rental amount of the monthly rent, basically. Okay, so landlord in this case was saying the rent was like $4,000 a month. The tenant was alleging that the rent was $3,500 a month, and we were in court on a non-payment of rent case. So guess what? Why the rent amount is important is to, if the landlord misstates what the rent is on a non-payment of rent case, that case goes away, basically. And this tenant in our case here was alleging that, you know, the landlord overstated the rent, didn't give the credits for payments. There was like one payment made to their entire tenancy, but there was always this dispute about the amount of the rent. So how does the court figure out what the right rent amount is and so forth? Well, in a lot of cases, what your attorney is going to have to do is show the court that, hey, the parties had what we call a meeting of the minds in contract law, or the parties agreed that these are the terms and conditions of the rental agreement. And in case of the amount of rent, the easiest way to show evidence that what the rent is what the tenant was paying the landlord. Okay, so I don't know what this commenter's dispute about the lease was, but if it was about the monthly rent, usually the easiest way and the most I'm losing the train of thought here. Probably the most reliable way to establish what the rent is what the tenant's actually paying. So if a landlord came to me and told me that there was a dispute about the rent and so forth, I would ask, my first question to the landlord is, okay, show me the payments that the tenant made, because that's indicative of what the monthly rent is. Okay. There may be some other evidence too that supports that, such as like text messages, conversations about what the rent was going to be and so forth, that could be used in court as well. So that might be helpful as well too. So, but payment of rent, basically, and usually, and if you show a pattern of, hey, you're getting $4,000 a month, the tenancy is like a year old and the tenant's always paid $4,000, that would show evidence of what the rent amount is. So your mileage is going to vary. I can't really tell from this comment what is actually in dispute, but it kind of just reminded me of that dispute I just recently dealt with in court. So landlords, tip of advice, it's always best to get your lease with all your terms written down, and everyone signs it and everyone gets a copy of it, so there is no dispute of the rent. One last thing I'll point out is, in my case, the parties never had an executed agreement, so that kind of made things harder on the landlord's end. But in this case, I don't know. It's alleged that the lease doesn't, landlord and tenant have a disagreement of what those terms are, it seems like. So when in doubt, other communications and other evidence showing what the terms are could be used in court. But for establishing price, payment would show that. So landlords, if you're facing this situation, you got a non-payment rent situation in the Northern California area and you need some help out, feel free to reach out. We might be able to help out. Put your comments, questions down below. Until next time, folks, I'll talk to you then. Thanks.